Good morning, everybody. Thanks for coming out so early in the morning. Excellent. Dive right in. I'm Jim Dempsey. Actually, here, I'm Jim Dempsey. I'm a lecturer at UC Berkeley Law School and senior policy advisor at the Stanford Center on Geopolitics, Technology, and Governance. Joining me is Bruce Schneier. He who needs no introduction. You can attend his keynote. When's your keynote, Bruce?
Tomorrow afternoon.
Tomorrow afternoon, Future of Democracy. Nick Lieserson is Deputy National Cyber, or Assistant National Cyber Director in the White House. Many years of experience on Capitol Hill before that. We had hoped to have today with us as well Chinmayi Sharma, a law professor at Fordham Law School. She came down with a wicked case of the flu on Friday, was in bed all weekend and unable to travel. And so yesterday, literally on the street, I bumped into Jonathan Cederbaum, professor of practice at the George Washington University Law School in Washington, D.C., former White House staffer, expert on a variety of issues, including sort of national security powers and executive powers of the president. And so Jonathan, who's been a part of a working group that we've been having now for over a year, looking at this issue of software liability, Jonathan agreed to step in. Unfortunately left us with a mantle, but apologies for that. So we got to give this disclaimer.
Do we?
Yeah, it's mandatory on all slides. And here we are back again. Now, I have put my email address here. It's easy enough, jdempsey@berkeley.edu. How many of you follow me on LinkedIn? Anybody here who heard about this? In order to try to get people here at 8:30 in the morning, I said that I would raffle off 3 copies of my new book, Fundamentals of Cybersecurity Law. Just recently updated with my co-author, John Carlin of Paul Weiss. And probably didn't need to do this, it looks like, to get people in the room, but I'm going to stick by my word. Send me an email, now or anytime, jdempsey@berkeley.edu, and at the end, we'll pick 3 at random for a free copy of my book. If you're a government employee and you can't take gifts, take it back and give it to your general counsel or put it in the library. Put it in the library. Okay. So our starting point here is March 2023. Nick, the White House issued the National Cybersecurity Strategy. 90%, I would say, certainly 80% of the Biden cybersecurity strategy was pretty much identical to the Trump administration cybersecurity strategy, 90% of which was basically the same as the Obama administration cybersecurity strategy, et cetera. But on this issue, Nick, a radical departure, something that no administration had ever previously taken on. So Nick, why don't you talk a little bit about the sort of premise and the recommendation of the strategy?
Great. Thanks very much, Jim. And yes, I think if you look at the National Cybersecurity Strategy, the President's strategy that came out last March, you do see, and we say right up front, right, that this is built on the back of national level policy going back to really the Clinton administration in 1998. But there are a couple of key strategic shifts that we want to make, and one of them is to put more responsibility for cybersecurity on more capable actors in the ecosystem. And the other is that we want to see more incentives for long-term investment in cybersecurity and resilience. And that is the through line across the 27 different strategic objectives in the strategy. But there is perhaps no strategic objective that better captures both of those shifts than this push for software liability. So what we're really going after here, right, is it's not liability for liability's sake. We're not saying, yes, we want to make sure people can sue software vendors. That's not the point. The point is to incentivize investments in secure software development. And liability is a tool that has been discussed for decades, 30 plus years. There have been law review articles, there have been computer scientists who say, this is very interesting that, when you look at product liability law in most other areas, there is some degree of liability, but not so much in software. But it hasn't really been explored much at the national level. In my previous capacity on the Hill, I worked on the Cyberspace Solarium Commission, and the last recommendation that floated into the Solarium report, literally the last thing we considered and approved, was to explore this idea of software liability, and the Biden administration took that one step further by saying, no, we see that there are consistent problems in terms of the security of the underlying code that we use every day, and our thesis across the strategy, part of that first shift of moving the responsibility, is to say we want to go to areas where there's very high leverage. And software developers, software manufacturers are very high leverage because software scales so well. So things that we can do to incentivize more secure development practices at the outset will really return huge benefits to the broader society that's actually using the software. And again, from our perspective, we looked and said liability is a tool that in other areas of product development has been helpful in incentivizing, again, there's that second shift we talk about, incentivizing investment. And we really wanted to explore how that might work in the software context. So that's where this language in the National Cybersecurity Strategy comes from that says there is this problem of just insecure code. Our thesis is that part of the reason is that the incentives are not completely aligned, in that users suffer from insecure code. They suffer because sometimes their products are exploited. They suffer because there's a lot of operational work that they have to take on to patch when something comes out because there has been a vulnerability. And we want to shift incentives such that some more of the cost that's being borne by users today is borne on developers, which will incentivize them to take more steps to secure their code. So that's basically the thesis.
And just so everybody's aware, this is the context. So the legal context, which is that today, essentially every contract or license, by and large today, of course, software is not sold, it's licensed, but every license contains a limitation of liability and a disclaimer of warranty. So the tradition that has built up as to, if you look, why is there no litigation on software? It's because these clauses have become the pretty much non-negotiable element of every software license, in which the developer of the software basically says, we are not liable. Even if we knew or should have known of the risk, we are not liable. The sort of magic words. How many folks are lawyers? Okay, not even that's cool. That's cool, because partly what we want to do is reach out here to the tech non-lawyer community. If you underline here, as is legal language. It's sort of the magic words that say, take it or leave it. This is it. We're not liable for anything. We're not warrantying anything. We're not telling you it's going to work. If you buy a car as is, a used car, basically what you're doing is you're buying a car that might not work. So as is, with all faults, this is language that is in almost every single software license, which again, this is why there was this misalignment of incentives, because the developers know and have known now for decades that these clauses are enforceable and that they protect them so no one even bothers to try to sue because you're going to immediately face this clause. So Nick, from the strategy, the administration said that it would work with Congress. Can you pick up on that just a little bit?
Yeah, so we released a strategy last March, and then we publicly released our implementation plan last July. So where we took the 27 strategic objectives and broke them into 69 different initiatives that the government is publicly committing to and saying this is how we're actually going to take steps to implement the ideas in the strategy. We said also that the implementation plan is an iterative document. You're going to see a new one every year as things are completed and we get follow-on actions that we need to move the ball forward. So the strategy says we need to work with Congress because our assumption, and I would say it's not 100% certain, but we were pretty sure, and we put it in the strategy as such, is that we'll need some sort of legislative action to effectuate a change in all of these contracts, as Jim described, that are already out in the field and have been for decades. But before we get to working with our partners in Congress, the first thing we said was, well, we need to do some homework. So if you look in the implementation plan version 1 that came out last July, it says, we at the White House, we're going to look across what the academic legal community, computer science community is doing in this space, look for ways that you could apply other liability regimes that have grown up to software, try and figure out what you would need to change from extant approaches to apportioning liability to deal with the unique nature of software, and use that as a starting point. So thanks largely to Mr. Dempsey's work with a group of experts that assembled in the wake of the strategy's release, we held a symposium at the White House at the end of March where we heard presentations from a lot of experts in the field about here are different approaches that one might take to effectuate a legal regime. What we've done since then is we've begun a lot of outreach to software manufacturers in particular. That's kind of our first stop. The White House is to say, now that we have a better grounding of what different legal regimes we might use we want to hear directly from developers about how applying some of these regimes would actually change their software development practices. Because again, our goal is not liability for liability's sake, it's to incentivize more secure development practices. That's where we are in the process right now, is lots of outreach to software developers. We eventually plan to expand that later this year to look at a broader community of stakeholders, including consumer advocates, folks in critical infrastructure. So if you're a power company and you're relying on software to help run the grid, how you might approach one of these legal regimes that we're exploring. And then the hope eventually is very much to take that, go work with Congress or through whatever authorities that we may have in the executive branch to start effectuating a solution, but with a firm grounding and understanding that we will actually be changing the incentives for secure software development. That is our priority, and that's why we're taking a longer approach to try and make sure we fully understand how a regime would be applied and that it would have the outcomes that we want to see.
So as Nick said, starting last April 2023, when I saw this come out, the strategy, clearly a big deal, and it raised at least 4 questions. Okay, if legal liability should be part of the sort of landscape for incentivizing more secure software development, and of course the standard is not perfection, right? The standard is just better than we're doing now. In no field is the standard perfection. But if we're going to develop a legal framework for software developer liability, at least 4 questions need to be considered. One, what is the legal framework? Do you use contract law and warranties? Do you use tort law? Do you use just straight regulation? You could just give some federal agency or create a federal agency, unlikely, but you could have a federal agency being the regulator, just as you have Federal Energy Regulatory Commission for the critical infrastructure, bulk electric power, et cetera. Secondly, I was obsessed with this question, which is, what is the standard of care? How good is good enough? How do you measure what is reasonably secure software? Third, construct a safe harbor, which was an essential element, I think, of the administration strategy, Nick, which is industry wants certainty. It just can't be reasonable, which is the term lawyers fall back on when they don't have a clear standard. What should be the standard? And then finally, how do you deal with open source, where often, of course, the resources of the developers are not going to be adequate to bear liability for the flaws in their products.
And I just want to foot stomp something that Jim said, right, which is perfection is not the standard. That's not what we're going for at all. As a very briefly, as a lapsed software developer now, I wrote a lot of buggy code, right? I could have done better. I was not the greatest software engineer on the planet, but also the incentive structure that was around me as a junior software engineer was not such that we were really spending a lot of time looking at ways to mitigate some of the security vulnerabilities that I know I was writing into my code, right? So we're not asking for perfection. That absolutely is not on the table at all, but it is very important that we change some of the incentive structures around how we ship code such that you're not handing the most junior person on your team control of the memory manager. That was what I was working on at a startup, where I had absolutely no training in secure software development, right? And it was kind of like, well, that's okay, because if this actually takes off, someone will eventually deal with the vulnerabilities that I was introducing on a daily basis. And that's the incentive structure that we want to change.
And as we were, Jonathan, you participated in a number of our calls and meetings, helped us organize the workshop at GW end of last year. This article, we were sort of bouncing around, and I was bouncing around. Should it be contract? Should it be regulation? What about tort law, negligence? Is that it? Where, again, it's the reasonable person standard. This article that Chinny wrote, and again, we're sorry Chinny can't be with us, this article, to me, was sort of an eye-opener, at least clarified a lot.
Yes, very good. Should I just offer some highlights?
Yep.
Okay, thank you so much. Let me preface my remarks by saying, as you've already heard, I am what the economists would call an inferior substitute for our original panelist, Chinny, but I'll do my best to present on her behalf a summary of some of the central ideas in the article she and a colleague wrote. They advocated for, and I think many of us have found persuasive, the notion of adopting products liability as a useful legal framework for incentivizing the production of more secure code. Products liability has 3 central advantages. First, it focuses on the end product, not the steps you take along the way. Negligence law, which may be more familiar to many folks here, pushes companies to ensure that they have taken certain reasonable steps. And in the software world, that might lead to a kind of compliance checkoff approach. The goal of products liability, because it focuses on the product that comes out at the end, hopefully would push companies to look for risks, search them out, and develop ways of addressing those risks. So it's a forward-looking incentive. Second, products liability is a very well-developed area of tort law. There has been litigation for decades across many, many industries, and that means that we have a very well-developed set of legal doctrines and procedures that could be carried over to the world of software liability, of course with necessary modifications, but we wouldn't be starting from scratch by any means. And third, and following on from that second advantage, in particular, over the decades, litigation under products liability has enabled courts to develop methods of dealing with how to handle expert evidence and how to help juries understand notions like causation, which are central to tort law. I think a lot when folks think about the prospect of litigation over software security, they understandably are concerned about the inability of judges and juries who are not technical experts grappling with and judging the adequacy of software. But product liability has developed a lot of doctrines to help judges and juries deal with that kind of expert information across many other industries. So those are three important advantages of the product liability framework. I wanted to also just quickly mention two misconceptions that I think a lot of folks may have about product liability law and may make people recoil at the notion of hearing product liability law. That seems very dangerous, a threat to software producers, software developers, and distributors. First, many people associate products liability with strict liability. That is, that if your product is not good enough up to some standard, you are automatically liable. Okay, that is not the predominant approach today in product liability law, and certainly is not the kind of framework that Chinny and her colleagues were proposing. Rather, like negligence law, products liability law does build in important reasonableness components. I'm sorry, Jim, that lawyer's uncertain, uncertain term does creep into product liability law as well. So, for example, typically plaintiffs in products liability law claiming that a product has a design defect, that there was a basic problem in how it was designed, must show that there was a reasonable alternative design that the product maker could have adopted instead. They can't just condemn the producer for having an inadequately secure product. And second, plaintiffs must typically show that the actual design adopted was unreasonably dangerous. Okay, again, that goes to the notion that we're not aiming for perfection. We're not seeking to impose liability if you have some security inadequacy in your code. No, it has to be a grave enough problem that it was unreasonably dangerous to put the code out there.
Thanks, Jonathan. Now, we're getting now into what I think is the hardest part of this problem. It's all really hard. But again, what is the standard of care? And Jonathan had described the traditional products liability standard, which is for any given defect, was there a reasonable alternative design that would have been safer? And if the developer of the product chose not to take that reasonable alternative route, but stuck with the defect, did that leave the product unreasonably dangerous or not reasonably safe? And so you sort of have two reasonableness determinations. Is there a reasonable alternative? And without it, is the product unreasonably dangerous? And to me, that still seems pretty open-ended. We figured it out with automobiles, but we've had 100 years, literally. The first major case on automobile product liability was in 1916, holding the manufacturers of the automobiles liable even though they didn't make the tire that blew out. Buick was still responsible for the car even though they didn't make the tire. And we worked that out, but my feeling was we don't have time with software to try to have this sort of case-by-case, jury-by-jury And of course, a lot of cases settle, which means you never get a determination. So I was torn between the process approach. One example is the NIST Secure Software Development Framework, and this outcome approach. Focus on the flaw, focus on the defect, focus on the product feature, not how did you get there. Don't fight over who made this decision, what were they balancing. Just look at what is the defect. And we have now from CISA this list of the most routinely exploited vulnerabilities. Think of a vulnerability as a defect for product liability purposes. And so I, in my thinking at least, have increasingly focused on what I consider to be this key insight from product liability law, which is to focus on the product, not the process. So again, given the choice between a process-oriented approach, under the process-oriented approach, you follow the process. If you still have a flaw, you're not liable because you followed the process. And to me, that seems like focusing on the wrong thing. One step removed from the real problem, which is the defect. So I looked deeper into this issue that we have in software, that year after year, the same kinds of vulnerabilities are emerging in software. If you look at the top routinely exploited vulnerabilities, and you go behind the vulnerability to what was the underlying weakness, what was the design defect, there's a certain number of design defects that show up time and time again on the list. And MITRE has a separate listing where they track weaknesses over time. And I think they have 20 on the list, and like 15 of the top 20 or 9 of the top 15 have been on every list year after year since they started compiling these lists 4, 5, 6 years ago. And so what this said to me was, can we at least start, and to me this is still a question in my mind, and we're going to be eager to hear from folks, can we at least start with certain no-nos? Again, rather than having perfection, can we start with certain frequently recurring mistakes in software design? And Bruce, you in your little piece about my article, you sort of came up with this, easy stuff in the middle, hard stuff. And I want to turn to you now for thoughts about sort of, are we on the right track here? Or is this, in fact, feasible to think about defects and underlying coding errors?
And this seems to be the fundamental problem we have in our industry. I mean, so if you look at some of the defects that are being talked about, they're things we knew about 20, 30 years ago, and they're still not being fixed. So let's step back to what we're doing. We're really addressing a market failure here. Right? The market is not incenting secure software. And we can talk about why. Largely, I think it's that the consumer is not sophisticated in that dimension, so there isn't a market benefit for saying, like, our code is more secure than the other company. Right? You're judged on features, you're judged on time to market, you're not judged on security because no one knows how to judge on security. So the market isn't solving this. So we need to shift the incentives, right? And that's how we get to liabilities. We want to put responsibility, someone said that earlier, put the responsibility in the hands of the entity that can fix it. We're already spending the money on insecurity. The problem is we're like paying ransomware vendors instead of paying security companies, right? So That's the structure. Now the devil's in the details. We've heard a lot about the legal details, which is sort of not my area, but let's get to the technical details. What can we reasonably expect? Okay? So we cannot expect manufacturers of computers to know about all of those timing attacks. Right? Remember Spectre Meltdown showed up a few years ago? And that came out of nowhere. And that would be unreasonable to assume that as a vendor you could fix that. Then you have the easy stuff. If you have a buffer overflow in 2024, that's embarrassing. And the only reason you have one is because, right, you hired a guy who was like so mediocre programmer, he became a lawyer to do your memory management, which is it. Right? So you establish what we think of as, the phrase we use is technical debt. Right? You get it working now, because that's what the market rewards, and you'll fix it later, but generally later never comes because you're always running fast or you're dead. And so that's what we're doing here. And so you've got the easy stuff, you've got the hard stuff, and then we're going to have stuff in the middle. The stuff that, well, could you have done that? I don't know. And we're going to need to figure that out. And I think rather than a regulatory agency deciding, like the FDA might for food safety, to have a litigation of experts where we figure out how the middle works is not an unreasonable way of doing things. I mean, there are problems with this. When you think about what the goal, right? I want to incent you to create more secure software, so I'm going to put this liability regime in place. So only the rich are going to get sued. The startups probably aren't going to get sued very much because they don't have any money. So you think about where the lawsuits are going. It'll be Microsoft sued. Microsoft's probably doing like some of the best. It turns this into a money battle. So when I think of cost of insecurity as waste, right? We're spending the money and not getting anything better at it. The litigation is also going to be waste. This is going to be, at least initially, an expensive process. Even made worse that nothing gets to go. I mean, you people, you talk about going to trial, you never go to trial, you people. Right? Everyone always settles, which means we don't get the case law we want. It's not going to be as easy because everybody settles all the time. On the plus side, the insurance market is going to come in, because what insurance does, it turns a variable risk into a fixed cost, which the companies are going to want. So the insurance market will be here, and then they are going to do a lot of that figuring it out. Right? If you want insurance from my company, you're going to have to do a bunch of things. I mean, just like you have to have coded electrical equipment. And this has worldwide benefits. The neat thing about software is it's write once, sell everywhere. Unlike a car where, environmental controls, the engine I buy in Mexico is not the engine I buy in the United States. Right? Nobody is going to have two versions of the software, one for the US, one for everybody else. Right? If we have a regime of liability that incents better software practices, everybody on the planet benefits. Which means, actually, if we can't do it, get the EU to do this. Right? Just as good. Just like GDPR benefits us all. Right? So I think there's a lot of tech that needs to be figured out here. But it gets the incentives right. I mean, I don't know about product liability versus anything else, but I just want the incentive structure to be moved properly, and then this stuff gets figured out, hopefully sooner rather than later.
So, as Bruce says, there are lots and lots of details in this concept to be worked out. The administration, by the way, knew from the outset this was a decade-long debate, a decade-long effort. Getting legislation through Congress of any kind is extremely difficult. Getting this through Congress would be very difficult. So this was the administration saying we need to start having this debate seriously. It needs to move from the world of academia where it arose. There are articles from the 1990s. I think there are probably articles from the 1980s on this question in law reviews. But the administration was saying this needs to come to the forefront and industry needs to engage with this. Now, again, this question of what is the problem with litigation, which is it often settles, this is again what drove me personally to say, could there be at least this floor of per se liability? The buffer overflow, where it's like, why are you still having buffer overflows? Now, it turns out, and I hope someone will bring this up, actually it's not that easy to find every single buffer overflow potential. At least that's what people have been telling me. But certainly my starting point was path traversal, a buffer overflow. Problems that are well known, well documented, have been occurring literally in some cases for 50 years. There should be this sort of floor, the quote unquote easy stuff, or at least the really dumb stuff. Beyond that, you do fall back on, or at least the only thing that I could fall back on was this concept of the design defect and reasonable effort. And then how to cap that, how to confine that so it's not completely open-ended, I would then look to the Secure Software Development Framework. I don't think the NIST framework is adequate for litigation. I think NIST would say they didn't design it for litigation. We need to come up with something else. But, you know, Bruce started getting into, and by the way, again, as Jonathan said, the tort law system has sort of dealt with a lot of this in other industries. So even the product liability, focus on the product, not the process, it does have a cost-benefit analysis. So that's the so-called BPL formula, which a judge with the amazing name of Learned Hand, there was actually a judge named Learned Hand.
Oh, that's fantastic.
Yeah, isn't that great? He came up with this test that said if the burden of the better design, if the cost of the precaution is greater than the probability of loss times the amount of loss, then the developer doesn't make the change. But of course, the developer has to suck up the cost of the damage. They pay the harm, but P times L, probability times loss, was less than the cost of hours and hours and months of software testing and review. So do it. So again, the law has developed these rules for how you assess liability. And by the way, it has a rule for, well, what if the product was secure, but then the user misconfigured it or changed the configuration? Well, the law shifts liability at that point back to the user under a concept called comparative or contributory negligence. Lots and lots and lots of details.
He probably teaches a class in this.
Bruce, you've already talked, so, I mean, there's a gazillion what-abouts. What about the impact on innovation? What about the treatment of open source? What about user error, which we just talked about, contributory or comparative negligence? What about the role of insurance? Big guy versus little guy. Bruce addressed that. I welcome people to start lining up at the mics for questions or comments. We're going to have at least 10 minutes for that. Just Jonathan, thoughts on open source and how one would deal with open source?
Sure. Let me just, again, I'm going to try to channel Chinny, who's also written particularly on the problems of developing a liability regime that recognizes the crucial role of open source software in the overall software development world. And there have been significant efforts by the government to focus on ways to encourage improvements in security for open source software. As many of you may know, CISA put out a roadmap for open source security development or open source security improvement that includes a number of steps that the government can take and that different stakeholders in the open source community can take, both on their own and together, to try to draw more resources to open source development and therefore have more resources to devote to security. But as you can tell from the premise of this panel, Chinny and others would suggest that we need to consider legal liability as well as a way of promoting improved security in the open source world. And Chinny's proposal with a number of colleagues is that the legal liability should be placed not on the open source developers themselves, but rather on the larger vendors that are incorporating open source products into their larger code bases, much like, to use Jim's analogy of car manufacturers, much the way car manufacturers who incorporate hundreds of products from subcontractors and vendors of various kinds into their vehicles are held responsible for the safety of those components. And what that does is it places a huge incentive on the big vendors who draw either on the auto parts or on the open software components to scrutinize the parts they're buying, the pieces of open source they're buying, look for defects, and either correct them themselves or demand corrections from the original producers. And that's the kind of approach that Chinny and company would suggest as an important component of trying to improve security standards in open source software.
Great, great, thanks. So for questions, please.
Hi, thank you. My name is Maria. My question is, would the initiatives described in this panel today affect in-house software built by B2C companies? What would that look like? And if there is a gap, how do we close it?
Yeah, but I don't think it's going to matter whether the software being built is being sold to consumers or used internally with consumer data. I mean, it's an interesting question, because is it not a product or is it a service? So I think the interesting thing might be, let's say Visa, right, is going to run a software for its own in-house dealing with credit card data. They lose a bunch of data because they have lousy software practices. Is that something that is covered here, and how? Because their product is the credit card.
So right now, I mean, as I conceptualize this, I was looking at it as a B2B issue. That is, you have the large developers of software, and you have enterprises that depend upon that software. And currently, the cost of loss, the cost of failure of the software is borne by the corporate user. In the B2C context, by and large, we already do have a legal framework that is arguably good enough, which is that the custodian of the data is responsible for the data. So if Visa or Experian loses my data, I sue them, and I have a number of theories on which I can do so. If the failure was not their fault, but the fault of the software developer, then, right, in a normal industry, in most industries, the entity that suffered the breach would then turn around and sue the entity whose product failed. But right now they can't do so because they've entered into one of these license terms that says you can't sue us. So the victim of the attack, the corporate victim of the attack, cannot currently sue. Partly what is being discussed here is, then shouldn't that victim of the attack, the corporation, be able to then seek indemnification or recovery from the maker of the software whose product failed? Okay?
Thank you.
Yeah, please.
2 points. The first is, while insurance works very well, it only works if everybody is required to have it. And if you're a poor startup, why bother to insure? Because the worst that can happen is you go bankrupt. And if you don't get a product, you go bankrupt anyway. So you have to require it. We do for automobile drivers. The second is that many of us have been damaged by organizations that we not only don't have a relationship with, we don't even know they exist. The most obvious is I have no IoT in my house. I work very hard to do that. I have still been damaged by denial of service attacks because IoT was not secured and was used as a weapon against me. So how do we protect third parties who have no contractual or other relationship with the damage?
Let me do something here. That's great question. Let me hold it and get in a couple of other questions if we could, just because I'm eager to hear sort of the scope of comments and thoughts on this, okay? So let's hold the sort of, chain of custody question for just a second. But
Thank
sir,
you.
thank you very much.
Yeah, what I haven't heard is any sense of sort of the responsibility of the buyer of the software are fit for purpose. Let me illustrate. In a previous life, I worked for an organization that made maps. We made maps that you could buy for $3. We made maps you could buy for $3,000. The expectation was if you bought the $3 map and then built a skyscraper at Gosh, you got it off kilter or something, don't come looking to us, you spent $3, what'd you expect? If you bought the $3,000 map, we had liability. I'm wondering about the same thing with software. I mean, if I buy a $19 software package off the internet, I should have lower expectations for what it can do than a $19,000 software. And if I take that $19 package and run it in a nuclear power plant, well, is it on me for having done that?
Yeah, I like that a lot.
It's a really good question.
I like that concept, and I think, Nick, there was an element of that in the administration strategy where it talked about higher standards for developers of critical software.
Yeah, so I think if you look at how we approach the problem right now, right, I think that's one of the factors that's going into development of a legal framework is how broadly should it apply, right, and should there be some degree of tiering associated with it. So certainly in the strategy we say that the expectations for critical infrastructure are higher. Those are operational outcomes, right? We expect that if you're operating a nuclear power plant that your security will be stronger than if you're operating a local bakery. So that's certainly the case. In terms of the security of the software being provided, though, I think there are questions as a policymaker that I have about, but what's the relative cost of delivering the more secure or less secure version, right? Especially if we're talking about bugs, not features. If we're talking about features and saying, hey, I have to develop and maintain a whole different feature set that maybe a consumer or a bake shop's not going to use, but a nuclear power plant is, I think that's a very fair question. If we're talking about mistakes in the code that are exploitable, I at least don't, it's less intuitive to me why there would be an expectation that, yeah, I've delivered buggy code that's exploitable because you didn't pay that much for it. Just in general, right, there are some things that we expect from a safety standpoint for vehicles that are wildly different from, the lowest end of the market to the highest, but they all have seatbelts, they all have airbags. There are some things that are non-optional.
We're totally running out of time. State your question, and then Bruce is going to close.
Real quick, I'll just comment that in addition to those clauses you're talking about, also in the U.S. we have mass arbitration clauses, and they'll try to limit their liability that way. And is this just going to mitigate this effort a bit, or is it going to gross negligence to the point that arbitration no longer applies?
No, definitely.
100%.
One of the whatabouts. We're going to do the raffle in just a second. You can probably still have time. Jay Dempsey at berkeley.edu. Sorry, folks, about running out of time. Bruce?
Let me start. mean, this is fundamentally not a tech problem. Right? This is an incentive problem. And if you think about the past 100 or so years, no industry has improved safety or security unless mandated by something like this. We think of planes, automobiles, pharmaceuticals, food production, restaurant sanitation, consumer goods, workplace safety, most recently financial products. Right? This is how we change the incentives. And weirdly, the superpower we have in society are the lawyers in this. Right? I mean, the notion that like something happens, just everybody sue everybody. Right? You sue your manufacturer, they sue their suppliers, everyone sues everybody, and then they figure it out. And they're actually good at figuring it out. Super weird, you wouldn't expect it. They have a lot of experience in this. And I think this is how we feedback and incent companies to spend the money in the first place to improve security when the market doesn't allow that.